introduction again. Okay, so I'm really excited to introduce Andrew Thomas, a associate attorney from Premick, Rogers and Downs, and he advises film productions, video game developers, and content creators on all the legal issues that they, might encounter. Before he became a lawyer, an entertainment lawyer, he studied theater at NYU, and he was involved in a lot of different films, including Martin Scorsese's Final. And he produced the short film Spiders, which was a 2016 Festival des Cannes short film selection. So he's not only a legal expert and can answer probably a lot of your questions, although he will have a disclaimer. He is a creative himself. And so he really kind of understands on a personal level what it's like to be wanting to protect your IP, wanting to know what your legal rights are. Okay. So without further ado, Andrew, take it
Thank
away.
you for thank you for the wonderful introduction. Yes, that's correct. My name is Andrew Thomas. Before we begin, I'm going to give a quick legal disclaimer. I am not your attorney. This presentation is intended as legal education and not as legal advice. So no attorney-client relationship is formed by you attending this presentation. If you do have an actual legal issue, then please reach out to a lawyer after the presentation and talk with them. So today, what we're going to discuss is we're going to discuss basically issues that I feel are important for any person who wish to work in the creative fields, and that is business formation, contracts, and intellectual property. Some of these areas get a bit overlooked when you're entering, and some of them you may be familiar with, but maybe not with the nuances. Now, I should say many of these are very complex topics, and they are taught in law school over the course of an entire semester. And I have 45 minutes, so I'm going to be trying to cover these at a high level. But if you do have any questions, feel free to ask them, and feel free to send me any follow-ups if you have any further questions. I always love talking about this stuff, so I would be more than happy to answer them.
Well,
Uh,
Andrew, can I just suggest that if you have questions, we save it towards the end just to make sure that we
yes,
get through the whole presentation?
yes, absolutely. So the first topic we're going to cover is business entities, and why you should form a business entity. Initially, many of you probably are not thinking about forming a business entity, but it might be something that you have to do later on. So, what a business entity is it is you're forming a company. And the first reason why you would want to form a business entity is for the limited liability. Limited liability means that the business is liable for any debts or liabilities instead of you personally. For example, if your business takes out a business loan, then the business is liable for that loan. Similarly, and this is especially important in terms of the arts, if somebody sues the business for copyright infringement, then the business is liable for that, not you personally. So, meaning like if you get found that you did commit copyright infringement, then the court is not going to take away your house. They'll just take away the company assets. Now, I should be clear that this isn't, you know, that's not just because it separates your business liability from your personal liability does not mean that you're going to be not impacted by what happens to the business. A lot of times when you are forming your own business, you are putting in a lot of sweat and effort, and a lot of times financial your own money into the company. So there are still stakes involved, and that liability shield is also not perfect. There are ways to pierce it if you run the company incorrectly. but the business liability is a major reason why you would want to form a either LLC or a C corp. The next is that it centralizes IP ownership. Um, I, as we'll get into later, IP ownership is a very big issue, and it can get very complex if you have different people contributing different artwork or IP. And if you don't centralize that ownership, it can get very complex. Next is taxes. There are a lot of tax benefits for that business entities receive that individuals do not. Now, I am not a tax attorney, so I I can only give you a high level kind of understanding of the taxes, but there are a lot of tax advantages that you would receive, and I would recommend speaking to an accountant. And then finally, business entities are a very easy way to share ownership and profits over, the what you're doing. So if you need an easy way to split profits with your business partners, forming an LLC is a great way to do that, as opposed to like entering into a bunch of contracts that can be very complex. So there are two types of business entities. There are LLCs and corporations. There are some other business entities that you might have heard of, like sole proprietorship or partnership. However, with those, you do not get the limited liability. You get limited liability with LLCs or corporations, not with sole proprietorships or with partnerships. So, what are the main differences of an LLC and a corporation? Well, LLCs are much more flexible in terms of how you set up and operate. You don't need things like board of directors, and you also get to choose how you get taxed. So an LLC can be taxed as a pass through entity, or it can be taxed as a corporation. A corporation, on the other hand, only gets taxed as a corporation. It cannot be taxed as what's known as a pass through entity. And that basically, what a pass through entity is basically you only get taxed once, instead of a corporation gets taxed twice. The corporation gets taxed, and then the shareholders get taxed. Whereas a pass through, only the shareholders get taxed. Corporations also are very strict in terms of how they are created and operated. But the advantage of having a corporation over is the growth potential. A corporation can take on investors, whereas an LLC is very limited in terms of what investment it can take. Corporations can also go public. So if you're thinking about doing a startup that's going to, take over the world, then you're probably looking at more of a corporation. For most freelancers or artists, LLCs generally are the way to go because they are easier to maintain. They are more flexible in terms of how they are operated, and you get flexibility in terms of the tax benefits. You can also, if you grow the LLC to a certain point, you can also switch to a corporation. That is a possibility. So don't feel like you have to get it correct, from jump. You can switch between the two, though switching from a corporation to an LLC is a bit more trickier. Not impossible, but yeah. So following up on that, the next area that we're going to discuss is contracts. And the main contract we're going to talk about is independent contractor agreements. As the name states, this is an agreement between an employer and a contractor. For most of you, I think at some point in your lives, in your professional careers, you're going to be working as an independent contractor or some form or fashion. So this contract really outlines the relationship of the parties, and it also addresses some key issues such as IP ownership. So this is a kind of list of the standard clauses that you'll see in an independent contractor agreement. I'm going to go into in depth more on IP assignments and the relationships of the parties in a moment. But in terms of the other ones, services that generally outlines what services you're going to provide to the employer. A lot of times you'll see that they'll have some boilerplate language in there, and then the services will actually be described in an attachment. Payment's also very important. Always look at that. We all want to be paid, so do not ignore that. Um, Term and termination will govern how long the contract is active. Um, it will also govern how you can end the contract. So if you need to end it because like the relationship has gone bad, then you're going to be looking at the termination clause to determine how you can end it. Do you have that power? Um, Confidentiality, all about keeping secrets. Most of us are familiar with concept of NDA. Most independent contractor agreements will have some form of language about keeping the company's secrets and what you're allowed to disclose and what you're not. And it's representations and warranties. These are basically where the parties make promises to each other. Like, for example, I promise I am not 18, or sorry, I promise that I am 18 years old and that I'm legally allowed to work. Also, a fairly common one is I promise that all the work I create is original and I did not steal it from somebody. These are contractual promises and they are enforceable, meaning that if you lie or break one of these promises, the other party can hold you accountable and have grounds for a breach of contract. Representations and warranties is often overlooked because the language can be a bit eye numbing. There's a lot of it. The sentences might run on, but if I would always look out in terms of the representations and warranties. Indemnification is an important but boring section, and it also ties into reps and warranties. Basically, an indemnification is a promise from one party to the other that if a third party sues, then let's say a third party sues party B, then party A will actually be responsible for the lawsuit. This is a very common clause within contracts, and it is some clause that most people are not aware of or really understand how it works. A lot of times you'll see a good contract will hopefully have mutual indemnification. So, like, if a third party sues you, I'll protect you. If a third party sues me, you'll protect me. But sometimes they might be one-sided, and it's important to understand what your obligations are in that. Limited liability is another section where it's a cap on how much you can recover if there's, like, say, a breach of contract. Say if the employer breaches this contract, then you're only permitted to recover so much, or you're only permitted to these kind of legal damages. Dispute resolution governing law will cover how, if there is a dispute, what law governs the contract, and then how that dispute will be resolved. And then the final section is the general or miscellaneous section. This is usually a lot of boilerplate language. You'll find, for me, this section is important, but for you, this probably is not as important. It's a lot of language that I'll read through to make sure that it's proper, but that may not be as important to you. However, if you do not see basic boilerplate language, that might be a bit of a red flag in a contract. So relationships of the parties is, it's the section that defines, the relationship between the two parties. So for an independent contractor agreement, it'll usually say, this agreement, you are an independent contractor, you're not an employee, you do not have the authority to speak on behalf of the company. yada 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 yada. There's a lot of language in there kind of saying the same thing. However, I'm here to tell you a bit of a secret, that this clause isn't as enforceable as you think. An independent contractor, that relationship is actually defined by the actions of the parties, not the language of the contract. What that means is, if the employer is treating you like a full-time employee, then you are more likely to be a full-time employee, and not an independent contractor, even if the contract itself says you're an independent contractor. Now, this, I should say that this is also very difficult, and a lot of companies take advantage of the fact that it's very difficult to prove misclassification, and that you have to kind of go through legal proceedings to show that you've been misclassified. So it takes time, effort, and money. But that, but that, what I want you to understand is that just because the contract says you're a independent contractor does not necessarily mean that that's what you are. Pay attention to how the employer is treating you. Each state has its own test for how it determines what's a full-time employee versus a contractor. Just to simplify it for you guys, basically, if the employer is dominating your time, making you work at the office, controlling how you perform the work, preventing you from taking other contract work, then you're more likely to be a full-time employee. So if they're dominating all of that, but then they're still saying you're an independent contractor, you're more likely to have been misclassified. Um, and I know that's a lot of information to process. And if you are ever in the situation where you feel like you're being mistreated or you are being misclassified, I would highly recommend talking to specifically an employment lawyer, somebody who deals with labor law and employment law, that that understands employment classification, and that can help you resolve that. And unfortunately, misclassification does happen a lot in artistic fields. A lot of companies, big companies, do take advantage of the difficulties of misclassification. So that's just something to be aware of as you progress into your hopefully creative careers. So the next part of a contract that I'm going to talk about is the IP assignment. Um, in order to talk about an IP assignment, I'm going to talk a bit about copyright law. So when a copyright is created, it is automatically given to the author, with one exception, which I'll get into in a minute. But that under copyright law, the ownership of a copyright can only be transferred by written assignment, which means that you have to have it in writing that I am transferring the ownership to another party. So what this means is when you get hired on commission to, like, let's say, make a piece of art for somebody, there has to be also accompanied with that a written agreement saying that you are transferring the IP ownership over to that other party. Even if they pay you, if they do not have that writing, there is no transfer of rights. So very like that. This happens a lot where people go, "Well, I paid them, or I paid this contractor to make this thing for me. Don't I own it?" No. If you did not get it in writing, signed by them, you do not own it, even if you paid them. And what can happen is, and this does happen, like let's say a video game developer hires an artist to develop something. They don't get the IP rights transferred properly. The game blows up. Well, then the artist goes, "Well, the game is really popular now. I would like more money, please, than what you paid me." And they are legally allowed to do that because you did not, the company did not get the proper IP assignment. Um, which A smart company will be more aggressive in regards to IP assignments for that exact reason. So the one exception I did mention is called the work made for hire doctrine. And the work made for hire comes from the Copyright Act. And this is when the law treats the company as the author instead of the human. And the work made for hire really applies in two instances: full-time employees and independent contractors. And it applies to situations differently. So a full-time employee technically does not need a written assignment. By law, the work is automatically transferred to the employer. However, the work has to be created within the scope of employment. So an animator at Disney, their work would be transferred. But a janitor at Disney that does like animation on the side, that would not count. That would not fall under the work made for hire doctrine. Even still, most companies, even with the exception for full-time employees, have written IP assignments and written work made for hire assignments within their employment contracts, just as a default, because it's always better to have it in writing. So the other situation is independent contractors or commissions. These do require a written assignment, and they do require it to be in writing that the work is a work made for hire. That's a specific requirement. So full-time employees, it doesn't need to be in writing, and it doesn't need to be specific. Independent contractors or commissions, it needs to be in writing, and it needs to be say that it's a work made for hire. Um, it, the reason why you want work made for hire is because there are other copyright laws that do not apply to work made for works that are deemed work made for hire versus just a normal copyright assignment. So some contract red flags, we've kind of gone over them a bit, but here's some more. First one, which is a huge red flag, is a non-compete clause. Non-competes prohibit you from working for a competitor. In California, non-competes are generally unenforceable. That is not true in every state. So if you move states, I'd definitely be aware that you might move to a state that allows for non-competes. I think a non-compete is a pretty big red flag because the policy reason for a non-compete is to really impact CEOs, not necessarily lower employees. You're trying to protect valuable information from getting into the hands of competitors. Companies can be a bit more aggressive with that, and they're really trying to prevent any information getting to their competitors. Another red flag is very broad confidentiality or IP assignment clauses. I know for a non-lawyer, this might be difficult to judge what is too broad or what is too narrow. But if they are asking you to give up everything under the sun in terms of the IP assignment, then that might be a bit of a red flag. This will also depend on the project you're working on. If you're working for Disney on the next Star Wars, they're going to have really aggressive confidentiality statements and probably pretty broad IP clauses too. If you're working for a smaller company that maybe isn't as high profile, then having really broad IP and confidentiality might not make sense. And that might be a red flag. So it depends on the situation that you're in. But just be aware of what the IP and confidentiality says. Again, one-sided representations and warranties or indemnification or limited liability, I would also take as red flags. Just to be aware of them if they're really one-sided and they're not willing to do mutual. Unusual governing laws. So if you are working in the United States, but and the company's in the United States, but they want, like, let's say Japanese law for whatever reason, that's a bit of a, that's a bit unusual. Most companies would want to do American law. So it's not, I wouldn't say it's a deal breaker, but just check out what law they're trying to say governs this contract, because that's the law that you're going to subject yourself to. And oftentimes, they're going to require you to go to that jurisdiction to enforce enforce it. Meaning you would probably have to travel to Japan if they chose Japan. And finally, as I mentioned earlier, missing boilerplate. For me, that's a red flag, and just that it's a indication of bad contract drafting. I care about the boilerplate because it is necessary to have a good contract, but if it is missing, it might be sloppy contract drafting, and that might be a sign that they are sloppy in other areas. So that is something to be aware of. Not necessarily a deal breaker, but that would definitely make me be wary. So the next topic that we're going to discuss is IP rights. For most of you, the two main IP rights to understand are copyrights and trademarks. There are other IP rights or things that are deemed to be in the IP umbrella, such as patents, right of publicity, trade secrets, and moral rights. Patents cover inventions, which can be very powerful tools, but these are dealing with technological inventions or new ways of doing things. Patents are very expensive and time consuming to acquire. So unless you are inventing new technology, they may not be as relevant. Right of publicity is the right to use a person's name, image, or likeness. So if you are hiring a famous actor to be, a model for your painting, then you would need to acquire their right of publicity. Right of publicity is also what's if you ever heard the term NIL, that is the same thing. NIL just stands for name, image, and likeness. Trade secrets protect secrets. These are law. This is kind of actually a form of contract law, but basically, trade secrets will last as long as as the secret remains a secret. Moral rights are interesting in that they are personal rights that are given to the artist. They give artists the right to control the artwork even after you've given away the IP rights. Generally, moral rights are much bigger in Europe than they are in the United States. In the United States, moral rights are pretty limited, and they can be waived. Whereas in Europe and especially France, that is not the case. They do come up here and there in the United States, but generally, especially where you'll see them come up is usually a clause in the contract that says that you're waiving your moral rights. So just be aware that that's kind of what that is. It's pretty standard practice. So the first, what we're going to talk about first is copyrights. Copyrights protect art. They protect artistic expression. Copyrights don't protect abstract ideas or functionality. As I said earlier, copyrights are granted as soon as the work is created. They are granted to the author of the works. You do not need to register your work with the Copyright Office to be afforded copyright protection. That is an important thing to know, that as soon as the work is created, you have a copyright, and that you can go stop other people from using it. Now, I do recommend you register your work with the Copyright Office because it allows you access to the courts as well as a special type of damages. So copyright lasts for the entire life of the author plus 70 years. For work made for hire, there are different rules. For work made for hire, the work lasts for 95 years from the first publication or 120 years from creation. The reason why there are two different rules is because Congress did not want to incentivize companies to just sit on copyrights. They wanted companies to use them. And so they wanted to give them protection, but not give them a way to have longer protection. So authorship has become more important in recent years. So in the United States, uh, only a human can be an author for the purposes of copyright. And this comes up in a very famous example in a case called Naruto versus David Slater, which is known as the monkey selfie case. This is a personal favorite case of mine. The picture that is shown here is a picture from that case. Basically, a photographer had set up cameras, and the monkey stole it. One of the cameras went up in the trees, took the picture of themselves, the selfie, um, left the camera somewhere. The photographer recovered it. He started selling the pictures in books. And then PETA sued on behalf of the monkey, claiming that the monkey owned the copyright and that the photographer was infringing the monkey's copyright. The photographer claimed he owned the copyright since it was his camera. The Ninth Circuit, which is the appeals court in California, said they were both wrong and no one owned the copyright. The monkey was found to be the author, but the monkey is a monkey and cannot use copyrights like a human can. Because of that reason, they said that no one owns the copyrights and that the work falls into the public domain. Where this is now percolating is in cases of generative AI. And so there's the major issue with generative AI is basically under current US copyright law, only humans can be considered authors. So if you make work using generative AI, then that work it cannot be protected under copyright law, and that's what the current standard is. So this in terms of how you incorporate generative AI into your workflow, it really depends on your comfort level, and it really depends on your risk tolerance. The example I like to give is that look, Disney probably isn't going to use generative AI to develop a main character's design because they're going to want to protect that. They may use it to put like trees in a video game or something where they're not so concerned about enforcing that copyright. It This is still an ongoing legal issue and it can change. I only touched on the part of generative AI as it concerns generating the actual artwork. Um, that isn't to, I did not get into whether or not they're allowed to train train on existing artwork. Generative AI is pretty complex right now and the law is changing, so this may just know that this is the current standard is that anything generated by an AI is not considered copyrightable. That isn't to say that that may hold in the future. So the next topic is about copyright infringement and what is copyright infringement? Well, basically, copyright infringement is when the defendant's work is substantially similar to the plaintiff's copyright. And in practice, the way this works is the court will look at the two pieces side by side and determine if they are similar. That's literally it. The judge sits there, looks at it, goes, "Yep, they look the same," and there's copyright infringement. However, what's been copied has to be copyrightable material. Not everything is copyrightable material. As I said earlier, abstract ideas are not copyrightable material. Also, human poses are not copyrightable material. And a really good example is a case involving the Nike Air logo. Nike based this logo based off the Jumpman photograph, the one on top. The Ninth Circuit ruled that Nike did not infringe that photo because Nike only took the pose, and the pose is not copyrightable. So there was no copyright infringement in that. So what you're really looking for is, did they copy copyrightable material or not? If they did, then there is copyright infringement. It's a difficult thing to nail down. So if you feel like somebody has ripped you off, please contact a lawyer. I also want to touch on licensing versus fair use. Licensing is basically when you grant permission to somebody to use the copyrighted work. Uh, we could give a whole talk. I could give a whole talk on licensing and how to go about it. But the important thing to understand is that licensing does impact your ability to both create art and to commercialize it. Licensing is everywhere. Um, it's, if you are using Adobe, you're utilizing a license to utilize the computer program. If you're using open source or Creative Commons, those are both licenses. Um, what's important to understand is what are the terms of those licenses? Do they allow for you to commercialize whatever you create? Generally, Adobe sort of does. There might be like if you are creating a video game, the video game is a certain level of success, then they might ask for certain royalties. But you'd have to look through the license agreements to determine that. Usually, these license agreements are found within the terms of service of like these computer programs. But if you are utilizing these programs, any program to create art or to create anything, uh, do understand that that is a license, and you have to abide by that the terms of those license. Now, you don't always need to license everything. Sometimes you can utilize fair use. However, I should state, and you probably have heard of the term fair use. Um, First, fair use is what's known as an affirmative defense, which means you have to go to court to assert it. Um, you cannot just claim fair use. A court will make the determination if fair use applies in this situation. And the second thing to also remember is that under fair use, you are actually admitting to the court that I am doing copyright infringement. It is not, you are in a way admitting to it. But what happens is you are saying, court, uh, my use is so important to society that you should allow it, even though I am infringing on their copyright. And the court goes, okay, you're right, and they allow it. And the way the court determines that is through a 4-factor test, which I have listed here. Fair use is a very complicated subject, and the term is often very misused in the real world. I swear I see so many videos on YouTube claiming this is under the fair use, and it is very not true. Um, in terms of creating art, this comes up a lot when you do things like collages. This art piece that you see is actually made by my mother, who made this collage. I think it's a lovely piece, but as a lawyer, it scares me because each one of those pictures you see you'd have to determine whether or not it is fair use or not, whether or not you would need to get a license or not. And you would have to do an analysis on each one of those pictures. So, with all that being said, what should you take away from this? Well, first, don't let the law stop you from making art, is the first thing I want to say. Um, this is not an endorsement to say you should go steal or plagiarize, but like, I did not stop my mom from making this piece. She just went and made it. If you are making an artwork that utilizes other existing art and you wish to share it or to commercialize it, then that's when you start talking to a lawyer to determine if you should get a license or if it might be fair use. But at the end of the day, I do want you guys to still create art and not be afraid that, oh, am I violating the law? Because that's my job, is to worry about that. So the final topic to talk about is trademarks. I'm going to run through this pretty quickly. So trademarks protect brands, logos, and like taglines. The technical term is a trademark is anything that indicates the source of a good or a service. Where this might come up for you is if you are trying to build your own trademark, or if they, developing a trademark for a company. Um, trademarks can get registered with the USPTO. There are a couple of different types of trade. There are two different types of trademarks: common law and a federally registered one. When we talk about trademark law, we're generally talking about federally registered trademarks. Um, and so then trademark infringement is basically when two marks are so confusing to consumers that there's a likelihood that there would be consumer confusion, and that's a term, likelihood of confusion. Basically, would if the consumers looked at these two logos, would they think that they came from the same place? If the answer is yes, then there's trademark infringement. Um, and with that, we are done. I know that was a lot of information. Thank you so much.
That was great.
I,
I'm going to hold off and see if anyone else wants to kick us off with a question. Yeah. Oh, yeah. And Ruby's giving you a digital clap.
Thank you,
Yeah, that
Ruby.
was great. That was great, Andrew. It's nice to have a professional, point of view. Okay, does anyone have questions? And you can type it in chat if you're feeling shy, and I'm happy to read it, or Andrew can read it out loud.
Yes, I
Okay.
have a
Okay.
question about scam job postings. There's an example that I saw a concept design job on LinkedIn, but I kind of feel like it is a scam because the job is quite clear. It says like creating concept, environment, prop, and creature assets for like a new project. But when I click in the company's website, it looks like really like an IT company. And when I check its service, it says something about the lawyer, and I kind of feel confused. Like, is this kind of job a scam, or it's
Yeah, so there are. It's always good to be cautious, especially with LinkedIn postings. There are a lot of postings that are fraudulent. Unfortunately, I don't know about you guys, but I get weird text messages almost every day, being like, "Hey, we have this job opened up at Amazon. Are you interested?" And I'm like, um, always be careful. Definitely look up the company, look up what they do, and look up, and then I would even, if you are really suspicious, look up people from the company, and then see if they, and then might maybe reach out to them and be like, "Hey, I saw this job posting. Is this official? Is this not?" I just wanted to make sure. A lot of the times they will be appreciative if it's a fraudulent posting, because there might be other legal issues where people are impersonating this company, and they want to be aware of that and take it down, because it reflects badly on them if people get scammed while they are while utilizing their name. It definitely just reach out to people and see what they say. Because also, if anyone ever asks you for money in a job interview, uh, that is a 100% scam. No actual job will ask you to pay, a fee or any type of,
Mhm.
retainer just to interview.
Or banking, or your banking information. You shouldn't have to
Yeah.
provide anything like that. Yeah, Marina, I would trust your instinct. And then I know we'll have an appointment. I'm happy to look at it too. If you want to send me the link or anything, I'm happy to also give you my opinion.
yeah, sure.
Uh,
Thank you so much.
Hmm. I've got a question. So,
Yeah.
what are some of the watch outs for misclassification in California?
So yeah, the way Miss California approaches misclassification is that it takes this as a they call it the ABC test, and they look at you know they look at the action of the parties. Uh, is this traditionally a job that is would be deemed an independent contractor? California has a lot of film and television jobs that are traditionally independent contractor jobs. So they like to keep those jobs independent contractor. The risk of basically as a full-time employee, you're entitled to certain benefits and to certain legal protections that an independent contractor is not. And and as well as the company has to pay certain taxes that they would not have to pay for independent contractor. So the incentive for the company is to try to classify you as an independent contractor so that they don't have to give you those benefits and they don't have to pay certain taxes. And in terms of so when you are being misclassified, then if you get reclassified as a full-time employee, then they have to pay certain penalties and taxes, as well as offer you certain benefits, such as um, unpaid maternity leave or unemployment benefits to the state. Um, uh, to be frank, employment law is a bit outside of
Hmm.
exactly what I do,
Yeah.
but it is when I've talked to employment attorneys, they have definitely said that misclassification is a very difficult thing to prove, and that a lot of companies do take advantage of it. I have one friend, his partner is, I believe she's an animator and she works for a company and he's an employment lawyer. And they're like, yeah, we've had conversations where, we think she's been misclassified, but, it is so difficult to prove and it, it's not worth it. So
Yeah.
the reason why I bring it up is more to if you ever are in a situation where things are getting really bad, then you can utilize that as a way of like, as a form of
Yeah.
leverage or
Yeah.
as a way to protect yourself of like, hey, I think I've
Cool.
been misclassified.
Great.
Um,
All right. I want to make sure we've got time for other questions.
yeah.
Um, who does anyone else have? I've got a couple more, but I want to make sure that you all have your questions answered. Okay, I'm going to jump in. What does someone do if they spot a red flag on a contract? Like,
So
what is the
yeah.
appropriate way to like address that?
So you can negotiate it. That's kind of, it sounds so simple, and I know it sounds very scary, but contracts and agreements are generally meant to be negotiated. There are some unilateral contracts, such as like when you do a terms of service, basically those what are called click wrapper contracts, where you have to click to accept. Those are unilaterally binding, but in general, if someone is offering you a job or someone saying, "Hey, we want to buy this," and they're offering you an agreement, then you are permitted to, um, look through it, provide edits into that agreement, and to send it back. And they're free to either accept them or reject them. But that's part of the negotiating standpoint. Uh, it, if you are scared to do that, then that's generally where a lawyer can help do that for you. Where we are not afraid of marking up a contract and sending it back to the other side. and advocating for our clients' rights. But what to keep out look at eye out for is to see if this agreement is fair to you and what type of you know what's the relationship going to be like with this company, because what this is kind of like the first salvo in the relationship, and it will kind of dictate how the relationship plays out. So if a company is, they say one thing to you, but then they put in all these red flags into the contract and they send it to you, and you see them and you're like, I don't know if I like this, then that might be a reason to just walk away, because because like they may be saying one thing but then doing another, and that might just keep continuing. If I engage with them, if I do agree to this job, or agree to do this project. So it's all, red flags are contextual, and it kind of depends on what your circumstances are.
Well, and I've noticed too, just in my own personal experience with like freelancing and contracts, I'm negotiating with the creative director or with someone else on the team who's hiring me.
Mhm.
And then when we kind of have a verbal agreement, we kind of talk about the scope, um, then then someone else in their company is sending over the contract. So I have one relationship with the person that I'll be like working with, but then
Right.
someone else like legal is sending over their kind of generic contract. And so there might be, of course, it's like overly protected because it's meant to be used for lots of different like ways, right? Lots of different arrangements and relationships. And so that's something too, I don't hold it against. I kind of keep that in
Yeah.
mind.
Yeah, that's the other thing, is that to understand is that a lot of times companies are using templated contracts that are generally one size fit all. They shouldn't be doing that, if I'm being honest, but it keeps down on legal costs. They should be tailoring each contract to you, but the it, they will generally be very overprotective of themselves, and that's where it's like, if you do push back, if you do say, hey, I'd like to adjust this here, in a reasonable manner, such as, like I said, doing mutual representations and warranties. So most people would be like, yeah, sure, we don't mind doing, we both are making promises to each other. So
Yeah,
that is something like the, the the trick with the red flags is to just be aware of them. And then if you feel like this is either a situation where I need help, then I know to go get help from legal counsel. Or if something feels off, then I feel comfortable walking away. That I don't
yeah.
feel like I'm putting myself into a bad situation. And like I said, it all depends on kind of the context of that agreement.
Totally. And I would say too, because I know we're at time, but just two quick points. One, with a contract, it can feel like it's like all in, like you have to like accept it or walk away from the
Right.
opportunity. And it's really the start of a negotiation, and it's really a collaborative conversation, even though it doesn't present that way. They're expecting, it's very customary to respond and be like, hey, there's a couple pieces of language in the contract that don't feel right for me. How about this? And that's totally normal and expected.
Yeah, and the you know you can always ask. If they reject it, then maybe ask for an explanation of why. You can always ask and always try to get a bit of more of a favorable deal.
Hmm.
There, if they are going, we're not going to change it. You have to accept it now, or we're taking the offer away. That in itself might be a red flag of like,
Yeah,
they are not willing to compromise. They're not willing to negotiate.
yeah,
Most reasonable companies, most reasonable legal departments are always willing to at least consider it and hear you out. And if and maybe make an adjustment here and there, they'll let you know things that are not negotiable. Things that they feel they're like, no, we have to have
Yeah.
this because of X, Y, and Z. But it's people are very afraid of contracts, and I'd like you to be not so afraid of them, and to think of them as this is um, this is the start of the relationship and kind of the first indication of how the relationship will go.
Yeah. One point I want to just clarify, because you were talking about governing law in Japan, as an
Yeah.
example. If the governing law is in another country, if the company is in another country, then it
Yes.
makes then that's appropriate. Like the company is in Japan and they want to use governing law in Japan. Well, that
Then
makes
yeah.
perfect sense.
Yes.
So
Yeah.
it's just if like, oh wait,
They,
the company is a US company, but they want to use like governing law in Guam or somewhere, then it's like, okay, what's going on
right.
with that?
Yeah.
Um,
That's where that yeah, sorry, I don't think I clarified that point, but that's exactly right.
yeah,
It's when there's a disconnect between the company where you're at and where the contract is being based.
yeah,
um, Most companies like to have the law be where they reside because they understand that law. So
yeah,
it is not strange for like Nintendo or other foreign companies to have their contracts be based in where they are at.
yeah,
But do understand that you are subjecting yourself to that jurisdiction's law. And a lot of times, I didn't really get into this, but there's also another provision that's usually tied to that called venue, which is to say, so there's what law governs the contract, and then where you're actually going to resolve the dispute. And where you resolve this dispute is venue. And a lot of times they'll be like, yeah, governing law is Japan, as well as venue is in Japan, which means you have to fly to Japan if you were to then like sue about that contract. So sometimes people don't take that in consideration of like the cost that it might be to like enforce a contract that uh, I'm not going to sit here and tell you that you're going to be able to change that because most major
yeah.
companies are not going to want to change that. But do keep that in mind when you're looking at it of like, oh, they're saying it's going to be, in the Netherlands and we have to fly to the Netherlands to like resolve this.
Andrew, thank you so much. This was packed with so much good. I learned so many things just listening to your talk. So thank you so much for being with us and sharing your knowledge. And thanks to all of you for showing up. And it's great to see your faces. Make appointments, reach out to me if there's a topic that you want to have a workshop about. And yeah, we're really excited to support our creative entrepreneurs. So hope to see
Yeah,
you all soon. And Andrew, thanks again. Really appreciate you.
it was my pleasure. Thank you so much
Yeah.
for having me.
Yeah. All right. Take care, everyone. Ooh, I love the party. I need to get that, Ruby, that filter. That's fun.
Thank you so
See
much.
you. Bye. Oh, Andrew, that was great.
Do you
Oh,
want to
wait,
stop recording?
yeah, I do.